Greetings to everyone. My name is Anika and today I will be explaining you about the case analysis that I have submitted for my assignment. The two cases that I had chosen was firstly Dinshaw Manekji versus Unknown and secondly Bennett Coleman and Company and others versus Union of India. Now let us have a look at these cases in detail. Firstly, the presentation that I have created analyzes these two landmark legal cases as these are a reflection to the corporate law and the company law emphasizing on their constitutional rights. The first case concerns about the tax evasion and the other concerns about the corporate wheel that is Dinshaw Manekji Petit Bart case. It is also known as Dinshaw Manekji versus the Unknown. And the second case addresses regarding the freedom of expression and government policy restrictions. The case which deals with the same is the Bennett Coleman and Company and others versus Union of India case. So both of these cases basically explore fundamental legal principles with their lasting implications. Now let us have a look at in detail one by one. Firstly, let us have a look about Dinshaw Manekji Petit Bart case. Now let us have a look at the background and the facts. As you can have a look at the pictorial visuals here, we can just analyze it in a very quick manner. We can see that a man is standing with a lot of money. Then we can see an image of private limited companies, and then we can see an image of a tax. So, what do you think? What can be the facts of the case? So, instead of you first guessing, let me first tell you that in this case, Dinshaw Manekji was a very wealthy and was a very rich man. So he was the individual who actually formed four private family companies, as you could see the second picture. Now, what these companies did, he used to use these companies to channel his income and avoid the super tax by splitting income into fake loans from the companies. So basically, as I already reiterated, that Dinshaw Manekji was a very wealthy and rich man. So when he set up these four family companies, he was the major shareholder, and the remaining shareholders were nothing, and the nominees were no one other than his family members. So also the income was used in these four companies and the income itself came to the family itself. So these companies held investments nominally on behalf of Dinshaw Manekji and his family members, but conducted no real business because the main purpose of setting up these family business was to rotate his income and evade the tax that so that he couldn't pay the tax. Now, this case raised major issues about whether the corporate wheel can be lifted to assess tax liabilities. Now, you must be guessing what corporate wheel is. We will understand the concept of corporate wheel through this case itself. Now, there were few events that was leading to legal challenges, as I said. Like Dinshaw Manekji, when he set up four private companies to hold these investments, basically he diverted the income through these four entities. Also, the companies which was created by Dinshaw Manekji were used to create fake loans to split income and evade super tax. Now, issues regarding corporate wheel and tax evasion. The key issue was whether the companies were mere shams created solely for tax evasion, allowing the court to lift corporate wheel. The court basically had to determine that if the companies had genuine business activity or were just pure paper entities to conceal income. So, this case explored the principle that corporate separation can be disregarded if used to perpetrate fraud or evade tax liability. Now, moving ahead, what was the judgment actually given by the court? So, since this case was registered in 1972, it was registered in Bombay High Court. So, the judgment also came from the same court, that is the Bombay High Court, in the year 1972. The court held that although a company is usually treated as a separate from its owner, that rule does not apply when the company is only a sham. In this case, the companies were created merely to help the assessee who was Dinshaw Manekji, who was actually avoiding paying the super tax by pretending to receive dividends and interest and then giving the money back to him as fake loans. The companies also did no real business and also had no control or ownership over the assets, and there was no valid transfers or trust deeds. The supposed loans were never repaid, showing that these were not genuine transactions but just a way for the assessee to hide his income. Therefore, the court decided that it's the time to lift the corporate wheel. So, therefore, Dinshaw Manekji proved the same, that corporate wheel can be lifted even when the companies are made for the family business, or even when the shareholders or nominees are from the family, if you're trying to evade the tax, because it's a breach and it's a criminal activity that has been done, or it's a misuse that has been done by the owner itself, and the company is not responsible for the same. Next, let us have a look at Bennett Coleman and Company and others versus Union of India. Now, in this case, constitutional rights, specifically Article 19, was discussed in detail. Now, let us have a look at the background, facts, and issues so that we can proceed to the judgment. Now, in this case, major newspaper publishers in the year 1972 and 73 newsprint policy, they challenged this policy called as the newsprint policy. Now, what did this newsprint policy do? This newsprint policy actually imposed limits on newspaper size, number of publications, and newsprint usage. The petitioners argued that these restrictions violated their constitutional right of freedom of speech and expression. Now, as you all are aware, right to free speech and expression is a fundamental right enshrined under Constitution under Article 19, Clause 1, Subclause A. So the Supreme Court examined whether the companies could invoke these rights and whether the policy was constitutionally valid or not. Now let us have a look at the legal issues and arguments about Bennett Coleman case. Now, in this event, major newspaper publishers actually challenged the 1927-73 newsprint policy, as I said, because these policy imposed strict limits on newspaper size, number of publications, and newsprint usage, arguing that it restricted their freedom of expression. Now, since this was the major changing moment of the case, these events triggered the judicial scrutiny of the corporate practices and constitutional rights, and hence the case was registered. Now let us have a look of the relation of the fundamental rights and the government policy restrictions as I specified. The Supreme Court here examined that whether the corporate entities like publishing companies could exercise fundamental rights such as freedom of speech and expression. So the legal debate here addressed whether the government imposed limits on newspaper print and newspaper size actually violated the constitutional protection under Article 19(1)(a), and whether emergency provisions bar challenges to such restrictions or not. Let us have a look at the petitioners and respondents' arguments on both the rights as well as the regulations. In this case, petitioners argued that the policy violated their constitutional right by imposing unreasonable limits. Also, the government contended that the corporations could not claim fundamental rights, emergency laws protected the policy, and the restrictions regulated the business operations, not the press freedom. The court also evaluated these competing claims in the context of constitutional safeguards and economic regulation. So finally, the Supreme Court, which was held by Justice Ray, ruled that these petitions were valid even though the petitioners were companies, since the rights of the shareholders and editors were affected. It also held that Article 358 did not prevent challenges to pre-emergency laws, allowing the 1972, which is and 73 newsprint policy to be questioned. Also, on examining the issue, the court found that press freedom is also very essential part of the right to free expression under Article 19(1)(a), which is the constitutional right right given to all the citizens of the country, and that restrictions like limiting the pages were completely unreasonable in nature, as they reduced both the news content as well as the advertisements, thereby curbing the press freedom. Also, the court struck down the newsprint policy as unconstitutional, but it upheld that any related newsprint order and import control order. Also, alongside Justice Ray, there was Justice Begg, who agreed that nothing that the policy went beyond what the import control order allowed. However, Justice Matthew was the one who dissented their opinion and argued that the policy did not restrict expression but rather ensured fair and efficient use of the newsprint policy monopolies, and therefore was valid. So therefore it was headed by a 4 to 5 judge bench, but after all, it was contended that constitutional right is being given to all the citizens of India. Article 19(1)(a) cannot be restricted in this instance case. Now, since we have seen both of these cases in detail, let us have a one-line conclusion to both of them. That is about the Dinshaw Manekji patent case and the Bennett Coleman case. Firstly, coming to the Dinshaw Manekji case, it confirmed that corporate wheel can be lifted when companies are sham entities used for tax evasion, emphasizing the accountability over formality. Because in this case, Dinshaw Manekji was the one who was evading the tax, and it was not the company's fault. Hence, the corporate wheel was to be lifted was completely valid and not invalid in nature. Moving to the Bennett Coleman case, it affirmed that corporations may invoke fundamental rights like related to speech, expression, government policies on press freedom, and imposing them unreasonably can be unconstitutional. So basically, both these rulings actually signified and shaped corporate law and constitutional jurisprudence. Thank you. That's all for today. I will be coming back with the next video soon. Thank you.